Hello, and thank you for joining us on the second installment of SDV's COVID-19 webinar series. I hope everybody is doing well out there, staying safe, and doing as best as you can in dealing with the present circumstances. My name is Richard Brown. I'm a partner with SDV in its Northeast offices, and as mentioned in the first installment, SDV is a firm that represents and provides advisory services to policyholders on all issues insurance coverage and risk management related. A large focus of my practice in particular is dedicated to franchising and franchise businesses, working both with franchisors and franchisees to evaluate and improve their insurance programs, as well as provide guidance through the claims process and litigate disputes with insurers to the extent necessary. This COVID-19 pandemic and the widespread shutdowns that have been ordered in response have been particularly devastating to franchise businesses across the country, as many of you are well aware. Many of the legislative initiatives that we are going to discuss today are intended to provide much needed financial support and assistance for those small businesses. And those small business groups that are most in financial need are largely comprised of franchised operations. So to those folks and everyone else out there that is joining us and taking the time to be with us today, we hope that this series provides some valuable insight and helps you through this difficult time. Today we're going to be discussing the legislative response to COVID-19 at both the state and federal level, and we will focus largely on legislation that has implications for business interruption coverage, which is a form of first-party insurance typically found in commercial properties or business owner policies, as well as some builder's risk policies. So let's just jump right in here. So since roughly late February, early March, of this year, there have been emergencies declared in all 50 states as a result of the coronavirus and the spread of COVID-19. During that same time, roughly 48 states have issued shutdown orders or shelter-in-place orders to one degree or another, which is intended to tamp down the spread and the curve of the disease itself. Now, most of these orders actually remain in place today. We're seeing some light at the tunnel in certain geographic areas throughout the country. So we are seeing some businesses being allowed to open back up, but most of these orders, again, stay in place today. As a result of them, what we're seeing in what is estimated to be in excess of roughly $450 billion in losses per month by small businesses itself. So needless to say, the financial impact has been staggering and nearly unbelievable. It's somewhat of a difficult thing to grasp as far as the losses here. So following on the heels of these mass shutdowns, many businesses have submitted claims for lost income, business interruption losses under commercial property policies, and again, business owner policies. So for the large part, most insurers have been lockstep with each other in terms of denying these claims across the board as far as what we've seen. There are typical virus exclusions as well as some preconditions to coverage as far as there being direct physical loss or damage to point to that these carriers have principally relied upon, again, in their denials here. So what you see here on this slide is largely the legislative response to the financial impact and those sweeping denials of coverage that have occurred. You'll see there's a number of states here: Louisiana, Massachusetts, so on and so forth. Now, these bills were initially introduced in New Jersey, Massachusetts, New York, Ohio, and Louisiana. And more recently, we've had Pennsylvania join the fray, as well as Michigan and South Carolina. A majority of these bills are aimed at providing businesses access to business interruption coverage for COVID-19 related losses. More specifically, nearly all of the bills focus on small businesses ranging from 50 to 250 full-time employees, as you can see in that final column there, identified as scope of application. They further mandate that any insurer offering business interruption coverage through policies in place on the date of a declared disaster or emergency within the particular state provide coverage for business interruption losses arising out of the COVID-19 pandemic or similar viruses or pandemic itself. Nearly all prohibit the denial of such coverage based on a lack of direct physical loss or damage, which we discussed a little earlier, and nearly all make void or prohibit the denial of coverage based on a virus or pandemic exclusion. Significantly as well, nearly all of the proposed bills either expressly or implicitly would apply retroactively to the current COVID-19 pandemic. Now, this is particularly important, obviously, for purposes of extending and achieving the intended result here of this legislation, and that would be to provide access to these small businesses to business interruption coverage for the losses that are being incurred in connection with this current pandemic. So that actually is one of the aspects of nearly all of these pieces of legislation that many have found problematic and troublesome, which essentially would result in the revision or modification of contracts that have been entered into and agreed upon by two private parties, insurance companies and their insureds. Those terms they've come to an agreement on, and what these bills would essentially do is allow the state, allow government to step in and unilaterally modify those contracts. So there's been more than a little uproar in terms of what's been proposed here, but let's look a little further at a few particular states. Pennsylvania. First off here, you'll see that there is 4 pieces of legislation that have been introduced. We have House Bill 2386, which is identified as COVID-19 Disaster Emergency Business Interruption Grant Program. And this is a little bit different from a number of these bills wherein it would not require insurers specifically to provide coverage for business interruption losses, but instead create an actual disaster emergency grant program. And businesses with 200 or less employees would have the ability to submit a claim for compensation for what would be essentially a grant under the program where they've been denied coverage under such business interruption and first-party coverage forms. So a little bit different there with House Bill 2386, but again, with respect to the issues that we discussed a little bit earlier and the challenges that most of these bills are likely to face if they are passed, this one's a little bit different, and we may see this have a little bit further progress in terms of ultimately being enacted and surviving challenge. So that's one to definitely keep an eye on in the state of Pennsylvania. We can take a look now at House Bill 2372. This is more in line with the standard that we discussed earlier in terms of what the bill attempts to accomplish, and that is it would require any property insurance policy in effect as of March 6, 2020, which covers business interruption losses as well as loss of use and occupancy to be construed to include coverage for those business interruption losses which arise out of the COVID-19 pandemic or specifically global virus transmission or pandemic. And you can see there that it applies to businesses with 100 or fewer full-time employees. So again, that's more in line with what we're seeing here typically with a number of these bills. The next bill that I'd like to talk about is very interesting in its approach. It's Senate Bill 1172, similar to HB 2372 in terms of mandating coverage for business interruption losses due to COVID-19 pandemic, as well as global virus transmission or pandemic generally. But they go a little further with respect to this bill here, and it provides a further framework for determining when access to coverage is actually made available. Specifically, the bill mandates that if a person tested positive for COVID-19 and has been present on a covered location, covered premises, or the virus itself is detected at a covered premises, that location will be deemed to have experienced property damage as it relates to this Senate Bill 1172. Further, businesses located within municipalities where COVID-19 or the coronavirus itself has been detected are deemed to have experienced property damage for purposes of coverage under a business interruption or commercial property form. So again, what's essentially going on here is there is an attempt or effort to modify contractual terms or demand that certain terms be interpreted in a certain manner, which would ultimately ensure that coverage is provided under these policies. The bill goes a little further here. We're still on Senate Bill 1172 in Pennsylvania. And this next piece says that the governor's order of March 19, 2020, requiring closure of all non-essential businesses constitutes an order of civil authority that would restrict access to business locations as a direct result, of physical damage at or in the vicinity of those locations. Further, the governor's order of March 19, 2020, again, constitutes an order prohibiting ingress and egress from such business locations as a direct result of physical damage at or in a vicinity of those locations. So the bill would deem certain circumstances or certain events as satisfying certain conditions to coverage with respect to business interruption losses itself. So interesting approach there. We have not seen that in any other state. This is unique to Pennsylvania, and obviously policyholders that have a stake in Pennsylvania or operations within Pennsylvania would want to keep an eye on that, and we definitely are checking in as to the status of those bills. Let's move on now and discuss New York specifically. We have two bills. One bill, Assembly Bill 10327, which was more recently introduced, as well as Assembly Bill 10226, which we've seen some amendments to of late. Let's discuss that Bill 10226 specifically. And basically, this is in line with the majority of these bills here, in that it would mandate that coverage be provided under business interruption policy or commercial property policy with respect to business interruption losses arising out of COVID-19 pandemic itself. The amendments that we've seen relate to its applicability and the size of business which could take advantage of the legislation. And it was initially written to apply only to those businesses with 100 or less employees. It's now been modified to apply to businesses with 250 or less full-time employees within the state of New York. Further amendments have explicitly voided any provision that would preclude coverage for business interruption losses based on a virus or disease. Again, Prior version did not explicitly have those terms in it, which addressed any type of virus or disease exclusion. So we now have that in there in the New York bill. Further amendments require automatic renewal of such policies that expired during the declared emergency. It's another unique piece of legislation there that we have not seen in any other state. Lastly, the amendments have expanded to apply the bill to both business interruption as well as contingent business interruption coverage. So another policyholder benefit there that we will continue to keep an eye on. The second piece of legislation in New York is Assembly Bill 10327. And this portion of New York's efforts here really relate to the access to business interruption coverage available to certain specified businesses that operate within the health services industries, including mental health providers, substance abuse treatment providers, and there's a whole host of specified lines of businesses that coverage would be extended to. And again, this is for COVID-19 related losses, business interruption related losses that occur to these specific lines of industry. The final bill that I really wanted to talk about here at the state level, which has some differentiation from what we typically seen here, is been introduced in Louisiana itself, and it's Senate Bill 477. This was introduced back toward the end of March, and it would apply to policies insuring against loss or damage to property, includes the loss of use and occupancy, as well as business interruption. Basically states that any such policies will be construed to include among the covered perils coverage for business interruption due to global virus transmission or pandemic itself. Notably, and I think we have a note up here, notably, Senate Bill 477 does not include any type of restriction in scope related to the size of business or number of employees above which it could not go in order to be qualified there. So again, some unique forms of legislation there, particularly as it relates to Pennsylvania. Again, all of those draft bills remain as such. Some have been moved on from the initial committees that they were introduced to with minor to no further modification. But again, all remain within the legislature, and they're going through those steps currently. Difficult to say whether or not any will actually be passed, but we are definitely keeping our eyes on the status of those bills. So just wanted to go through and discuss further what the upshot of most of the legislation is, again, in attempting to accomplish here. These bills would essentially mandate coverage, again, for the loss of use and occupancy and business interruption losses arising out of the COVID-19 pandemic and similar pandemic going forward. Prohibits insurers from denying coverage due to a lack of direct physical loss or damage to property, as well as the voiding or prohibition of carriers' use of virus exclusions for purposes of denying coverage for such business interruption losses. Another key point that, again, is the cause for a significant amount of pushback from the insurance industry and other trade groups: retroactive application. These bills, most of these bills expressly state that they would apply from the date of a declared state of emergency within the particular jurisdiction that they're being considered in. Also very important, each of these pieces of legislation, save for the two that I mentioned earlier in Louisiana and Pennsylvania, are generally restricted to small businesses, again, ranging from 50 full-time employees up to 250 full-time employees, as we saw with the New York legislation. So important points to keep in mind there. Check in with us. Check out our resource page at sdvlaw.com to see further updates as far as where these legislative initiatives stand. Let's move along here and get into a further discussion regarding what we're seeing more at the federal level now. So the first piece of legislation that I wanted to discuss is what's being identified as the Pandemic Risk Insurance Act of 2020. Again, at the federal level, there's been a discussion draft of this, what's being identified as PRIA. It's been circulated among a number of legislators, and it's getting widespread support from both sides of the aisle, as well as both insurance industry groups, as well as policyholder advocates. So there's widespread support for this program itself and this piece of legislation. And you'll see as we go through it that this would seem to make a lot of sense in terms of providing a backstop that can be relied upon when confronted with circumstances as we are here with a global pandemic that has such a sweeping and widespread financial impact as it has to all businesses, again, throughout the country. So PRIA itself, the piece of discussion draft legislation here that's being provided throughout Congress, it would mandate coverage for participating insurers for business interruption losses. Again, for business interruption losses resulting from outbreak of infectious disease or pandemic. And here's a couple conditions of the program itself. There would need to be a declared emergency or major disaster by the president. And in addition, there would need to be a certified emergency or disaster by the Secretary of Treasury. So a couple preconditions there that would be necessary in order to trigger access to the program itself and access to the pandemic risk reinsurance fund that it would create. So again, insurer participation is voluntary, and the program would essentially act like a federally funded reinsurance program for business interruption losses, again, due to infectious disease or pandemic. Once covered losses reach $250 million, okay, the fund itself that's created here would be triggered with the Fed covering 95% of all further losses, again, beyond that 250 million, up to the annual limit of $500 billion. So it would be the creation of a substantial fund here that would be accessible for purposes of subsidizing those claims that, again, are above that $250 million mark. Essentially, insurance companies would be able to submit claims for reimbursement of again, 95% of those losses above that mark. You'll see here also retroactive application. The piece of legislation that has been introduced here does specifically state that it would be retroactive, making its benefits available to policyholders in connection with the current COVID-19 pandemic. So significant piece of legislation there. And in my opinion, this would be a piece of legislation that would make the most sense. You'd have it at the federal level as opposed to a patchwork of states that have utilized or implemented different forms of relief here. As we saw in the prior slides, the federal program itself would be centralized, and it would be, I think, a much more effective route to take at this point. And again, it's been reported that this piece of legislation itself is getting widespread support. So we're hoping to see some further action with respect to PREA itself. And given the scale of losses that have been incurred, it seems that likely Congress would act on PREA or similar piece of legislation that we've seen. So let's move along here to another piece of legislation that we're seeing at the federal level. And this is being identified as the Business Interruption Insurance Coverage Act of 2020. This was introduced April 14th, 2020 in the House of Representatives, and the proposed legislation would require that any insurer offering business interruption coverage make available coverage and specifically extend coverage to losses resulting from viral pandemics, and it would essentially mandate civil authority coverage as well, forced closures of businesses or mandatory evacuation by law or order of any government or governmental office or agency. More or less what is typically identified within such commercial property forms as civil authority coverage. No restrictions based on number of employees or size. So we don't necessarily have that component as we've seen with the state-sponsored bills. And one criticism of this bill here is it does not specifically address the requirement or precondition that there be a direct physical loss or damage to property. And it does not explicitly reference COVID-19. So while it is being interpreted and understood to apply retroactively, it does not specifically address or call out losses related to COVID-19. My reading of this bill itself is that it is not as thorough as what we're seeing with the prior bill being considered at the federal level, the PREA legislation. It does not offer any type of funding component or subsidy for what would be a massive amount of losses to require insurance companies alone cover. So we have not seen as much support for this bill or movement in terms of progress within Congress itself. But again, something to keep your eyes on and remain aware of as time goes by. So we wanted to address some additional legislation that policyholders throughout the country should really be considering here. And I wanted to identify certain pieces of legislation that you're seeing be introduced in a number of states throughout the country, and they have what I believe is widespread application here. So most recently, there was a bill passed within North Carolina, and it relates to the limitation of employer liability arising out of exposure to COVID-19 and the coronavirus by employees. So it would essentially act as a shield to claims and to liability for employers. And North Carolina itself has limited this bill to certain first responders and healthcare workers. There are a number of other states that have or are considering similar legislation. There's also a bill more recently that was introduced at the federal level that, again, a number of states are getting behind as well and urging Congress to consider that would effectively do the same here as this North Carolina bill in limiting employers' liability for exposure to an infection of employees while at work. So the next bill that we have here relates to workers' comp benefits, and I believe it was California that kicked off the effort here with a piece of legislation that created essentially a rebuttable presumption that an employee that contracts COVID-19 would do so and has done so at work. Creates again a rebuttable presumption that they were in fact exposed and infected while at work for purposes of qualifying and accessing workers' comp benefits. You'll see here there's a number of states that have enacted similar legislation or regulations: Louisiana, Massachusetts, New York, New Jersey, right on through. So that is a piece of legislation that I believe we're likely to see, if not across the board, in a vast majority of states. Paid sick leave in a similar fashion, not yet as wide scale though. We're seeing Massachusetts, New York, North Carolina, California. They've mandated a period of sick leave, paid sick leave for certain industries or lines of business, grace periods on the payment of premiums, and the prohibition of cancellation of insurance policies. This is significant here. We see California, Florida, Georgia, they've all implemented some form of grace period with respect to the payment of premiums. New Jersey as well. I don't have that up there on the slide, but New Jersey as well. And, I believe that the grace period on payment of premiums in New Jersey is 90 days. I think we're looking at a period of 60 days in New York. And again, significant with respect to the prohibition of policy cancellation during that declared emergency or COVID-19 pandemic itself. Rent abatement and forbearance, similar to the last one as well, moratorium on foreclosures and evictions. A number of states here have enacted legislation on both of these fronts that are widely encompassing both residential as well as commercial rental properties and mortgages. There are others that are more limited and broader in scope that apply with respect to residential property, and others that are only limited to commercial properties. But it's important to be aware of this legislation and where it stands in your particular jurisdiction or state, and really how it impacts you and your business. So it's important to be aware of not only these, but other pieces of legislation that are being considered and have already been enacted that bear on your position and your business. Again, as we work through this COVID-19 pandemic and begin to put these circumstances behind us. So important to stay on top of that. And again, we have a number of resources at our site, sdvlaw.com, and the specific coronavirus resource webpage that we've established. There are also a number of governmental links that I believe have been posted up there as well that provide updates on these pieces of legislation. So if you have the opportunity to go there and keep informed, let us know if there's anything else that we would be able to assist with on that front. And again, I just wanted to thank everybody for taking the time to join us today. I hope you found our discussion informative, and to the extent that you have questions or would like to discuss any issues further, please feel free to reach out to me directly. As I said before, also go to our website at sdvlaw.com for this information, as well as additional information related to COVID-19 and insurance coverage generally. Also, we are on social media. Take a look there. Feel free to reach out to our attorneys, and stay safe, and be sure to catch the third installment of our webinar. The series will address the implications of COVID-19 in the context of directors and officers coverage. Again, stay well, and we will see you soon.